Hello, it's Phillip Taylor from Richmond Green Chambers speaking, and this morning I'm welcoming a book which has come onto the market from Hart Publishing, which they've kindly sent me, which is called Privacy Injunctions and the Media, a Practice Manual. It's written by someone who's very well known to many of us, Iain Goldrein Queen's Counsel. This is the book here. It's a heavy book, a nice interesting purple mauve colour. For the book itself. Let me just show you what it looks like. The work itself is, you've got to be a bit careful with the pages, but there is in fact a very useful index at the back. What you have got is the front cover, and you've also got the side and some comments on the back of the book itself. Explains who Iain Goldrein is, but I want to show you the book because it's actually a very important one. It looks very in a great deal of detail at where we are at the moment with the whole issue of privacy injunctions. There's the contents page at the beginning, and I'd like to show you part 21 in particular. That shows you the keywords for what is actually half of the book when you look at it. This half here, the last half, called the Case Digest, and there's a lot of information there about some of the leading cases, going back a while in some instances, but it's extremely helpful, and it's a very great contribution in terms of how people are going to deal with this sort of application for a privacy injunction, and when they deal with the media in the future. And this could well be post Leveson, of course. We've given it the title on the web and in the journals which we sent the review to of Best Practice in Seeking or Opposing Privacy Injunctions, Comprehensive and Easy to Follow Advice. And that's what it is. Hart have come up trumps here. The role of the media in a free society, as we know, has been widely scrutinised and commented upon of late, which is why the recent publication from Hart is to be welcomed and very timely. The purpose of the book is to set out best practice with respect to privacy injunctions, how to prepare the privacy claims, conduct them and prosecute them, if I can use that correct word. As Lord Neuberger mentions in the foreword, the book provides a practical guide to the way in which the courts have developed the law of privacy in the past decade or so. Whether they accept there's privacy law or not, the fact is there are guidelines, and this book is the one book I think on the market which will assist. Underlying all the developments is of course the perennial clash, tug of war between privacy and freedom of expression. Personally, we favour the latter over the former, and certainly there isn't a journalist out there who doesn't in our view, and few lawyers of course who don't. However, whatever side of the fence you're on, you'll be more interested than not in the book, whether you're seeking or opposing a privacy injunction in our view. Looking at journalists in particular, the watchdogs of the freedom of our society, Goldrein furnishes a quote from Lord Judge, who, commenting on a case in 2010, reminded us that very few citizens can scrutinise the judicial process. That scrutiny is performed by the media, acting on behalf of the body of citizens. Without the commitment of an independent media, the operation of the principle of open justice would be irremediably diminished, and I think that really does sum matters up quite well. Let me conclude by saying, to aid further research as well as enhancing case ease of use the book provides amongst other materials a user's guide and at least 27 pages of cases and of legislation. Of course, the Case Digest at the back is of particular relevance because of the detail. For media folk, media lawyers, or anyone else seeking information and practical guidance in this rapidly developing area, I think the book is a very useful acquisition. The publication date is 2012, and we await what is going to happen in the future. Thank you very much to Mr. Goldrein and also to Hart for continuing the debate. Bye-bye.